Welcome to today's verdict. I'm your host and trial attorney, David Lesh. We took most of August off because we were tired, but we're back and we're refreshed. I have three great topics to discuss today: freelancing, non-compete clauses, and radio encryption. Three great guests coming your way. So stay tuned. Today's verdict starts right now. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have joining us today, Eric Thurm. We're going to be discussing freelancers and freelancing. How you doing today, Eric?
I'm doing great. Thanks for having me. Excited to be here. Excited that this new law has gone into effect. That's going to protect a whole lot of people, I think.
Now, you wear a few hats, I think. What organizations do you work for?
So I am the campaigns coordinator for the National Writers Union. We represent a ton of different freelancers across a lot of different media. So that's not just writers. It includes people who do video editing, people who do like audio, design, all kinds of other work. And I sort of came into that through the Freelance Solidarity Project, which is a division of NWU. So we sort of represent like a lot of different kinds of freelancers. It's maybe unnecessarily complicated, but freelancing is like that too.
Well, let's try to uncomplicate it. What is a freelancer? I mean, how would you describe in layman terms someone who does freelancing work?
Sure. So, if you are someone who has mostly done sort of standard, W-2 work, freelancing means that you are getting hired and doing work on a sort of ad hoc basis, which means you're contracted for a specific project, paid ideally upon the sort of completion of the project. That can take a lot of different forms. But it means that you sort of are doing a one-off job rather than being hired as a full-time employee. The sort of pitch, generally speaking, is that freelancers have more flexibility. You get to set your own hours, sort of take on jobs that you want. And sometimes that's true. But the trade-off is that you don't have guaranteed health insurance. You don't have a lot of other benefits. And really your work is super contingent on just like it can be a lot of different people.
Okay, let's talk about this. The Freelance Isn't free law, which I think you're very proud of. What was life like before this law?
Well, I think the way that it still is for a lot of freelancers, which is that you are sort of just at the mercy of whoever is hiring you. One of the drawbacks of freelancing is that often you are really isolated. Even if you're being contracted by a really big company, you don't know the other people that are working there. And it makes it very easy for whoever's hiring you to just decide that they either don't want to pay you or that they, will pay you less in exchange for paying you on time.
It's not like you could just walk into an HR, human resource suite and say, look, I haven't been getting my paycheck. What's going on here? Of course they'll help you out, or I haven't been getting my insurance, or who do I contact for this issue? You're on your own, really. It's uncharted territory. For yes, you make your hours, and yes, you make your own schedule, and that's wonderful, as long as the money's coming in. What does this particular law do to protect freelancers now?
So this law is sort of building on a law that has been in effect in New York City for a few years now. The basics of the law are one, that if you sort of do enough freelance work to qualify under the law, you're entitled to a written contract, which you would think would be like extremely basic, but a lot of freelancers don't work with one and often are sort of told, that in the name of flexibility, that the person who's hiring them, would prefer to work without a contract. And if you don't have that, it becomes much harder to, enforce the terms of your work. you have the freedom to sort of negotiate the terms of that contract and the terms of your work without being afraid of retaliation. And probably most importantly, you have the right to be paid on time for your work. And the default of that is within 30 days of the completion of the project, you have to get paid.
What was the hardest thing to fight for? Where did you get the pushback from this particular law? Was it, paying within 30 days? Where was the defense?
So weirdly, we got very little to a lot of the substance of the law. The biggest problem that we had was, this law first passed the New York State Legislature in 2022 and was vetoed by the governor for sort of nebulous budgetary reasons that were related to the, Department of Labor essentially not wanting to enforce the law. But thankfully, the Attorney General's office stepped in and said, like, we're happy to handle the enforcement. And so with that sort of secured, we were able to get it passed again in 2023, with that, I think, being pretty much the only change. And now that it's gone into effect, the Attorney General's office sort of has the ability to like enforce those contracts and, make sure people are getting paid. That was the big sort of snag.
So now we know we have mandatory contracts. We have 30-day payment terms. What's protections against retaliation? What does that clause mean?
So it can mean a lot of different things, depending on like what you're being retaliated against for. But
who's going to retaliate against a freelancer? I don't understand it. I mean, I understand, in my business, in the law, there's retaliation where if you sue me, I'm going to evict you. I'm going to evict you. And somebody says, Mr. Lesh, I'm afraid of bringing this action against the landlord, because my landlord, even though I got hurt because he said he's going to throw me out. Well, that's retaliation. That's how it affects my business. How does a freelancer become retaliated against is what I'm asking, really.
So that all comes from the hiring entity. So the retaliation is specifically, if you say, I would like to be paid a certain amount, even, if you're negotiating, sometimes hiring entities will say, like, listen, you're being difficult about this, and, we're going to, like, cut the rate even further. A lot of the time people say,
yeah, but that's just basic contract negotiations. I mean, that happens not just in freelancing, that happens in anybody who works for a company. You're always trying to get a higher salary, or you're negotiating against yourself. So there's got to be something else, something more to it.
Well, I think a lot of it is that in other contract negotiations, right, you have somebody else that's doing the negotiating rather than just like, oh, we want sort of better terms. A lot of it is about like asking for, sort of the basic things that are guaranteed in the other part of the law. So the most common example of what this is intended to sort of fight back against is employers who will say, we will pay you on time, but only on the condition that you give up some amount of the money that you're owed. So we'll pay you like 85%, and then we'll pay you in 2 weeks, or we'll pay you in like 6 months if
Well, I would assume that would come under the 30-day payment rule or the mandatory contract rule, or not against the retaliation. It's still vague to me, but listen, what do I know? But I do know one thing. We really appreciate you coming on today. And you taught us a lot about freelancing, because there are a lot of people who do freelance work, and we certainly want to make sure they're protected. Maybe you can come on again in the next couple of months. Let us know how things are with the Freelance Solidarity Project.
Yeah, I'd be happy to do that. We have New York is actually the second state to have a similar law went into effect in Illinois a couple months ago. Another one is hopefully about to go to the governor's desk in California. So we're really hoping, that these will sort of catch on and build a little bit of a baseline for protections for freelancers, across the country.
Well, Eric, it was good meeting you. Please come back. And for the rest of the viewers, stay tuned. Today's Verdict will be back right after these messages. Okay, welcome to today's Verdict. I'm your host and trial attorney, David Lesh. We're returning here with Michael Schmidt, the vice chair of the Labor and Employment Department in the New York office. He's the office managing partner at Cozen O'Connor. Michael, thanks for being here today.
David, thanks so much for having me.
First and foremost, maybe you could talk a little bit about yourself. Where are you from? What's your story?
Sure. Born and raised here in New York. I've been with Cozen O'Connor for the last 19 and a half years, and I've been practicing employment law for the past 30 years, really on behalf of employers and management for the most part, and deal a lot with non-compete and other restrictive covenant issues.
And by the way, you also have a podcast.
I do have a podcast. Thank you for that plug. It's Employment Law Now. I've been doing that for about 7.5 years. This next week will be my 150th episode. Bring on great guests talking about a whole wide variety of employment law issues and cases and developments that appeal to both sides, the employer and the employee. And it's been a labor of love, pun somewhat intended.
Let's start from the basics. What is a non-compete clause?
A non-compete clause is essentially a provision in some contract that prohibits an employee from going to work at a competitor or from starting a competing business to compete with the employee's current employer for a period of time.
The non-competes, are they limited to a certain duration? Is it usually a 2-year, 5-year, 10-year, whatever? Does it depend on the industry you're in? How would you characterize the length and duration of the non-compete clauses?
Those depend by employer and by position. And I think we can get into this certainly in terms of whether judges and government agencies look kindly on non-competes. But when you're talking about the reasonableness of them, they tend to fluctuate between 6 months to a year for a non-compete clause that is more likely to be enforceable than not.
Well, let's get down in there. Well, there are many people who think they can get past the non-compete and they go and they try and find another employment. And sure enough, next thing you know, they're getting a summons in the mail. What's your thoughts on that? I mean, I think there probably was a time when people figured it was just, I have a non-compete, but I only have 6 months to go. What's the big deal? They won't care. What are your thoughts on the whole industry with respect to non-competes?
Well, there are two aspects of this. There is the sort of law aspect of this, and there is how are judges looking at this when the case comes before a judge, if a lawsuit is filed. And just for a little bit of context, over the past few years, I think judges and those responsible for enacting laws have really looked less kindly on non-compete provisions, partly because they have started to be used with employees who don't really have trade secrets or real confidential information, or they're not working in positions that are a threat to the company if they were to leave. And I think what you're seeing out there is legislatures, state attorney generals, and in fact, judges who are saying, hey, these non-compete provisions have in some cases been abused. So we need to act to restrict the enforceability of these non-compete provisions, particularly with positions or lower wage earners who are, in many cases, forced to enter into these as a condition of employment.
Well, let's contrast the federal and the state laws with respect to non-compete. Where do we stand in New York compared to the federal government?
Sure. So in New York, we had a bill that was proposed in Albany last year in 2023, which almost mirrored what the federal proposed rule was this year in 2024. And the New York bill was vetoed by Governor Hochul at the end of 2023. I suspect that we will have another version of that bill proposed at some point, if not by the end of this year, certainly in 2025. And we will see. I do suspect, though I'm not a betting man, I do suspect that New York will see some sort of statutory limitation on the use of non-competes, but we'll have to see what that is in form.
I'm curious what industry pushes back the hardest. Like I would think, Amazon, but they don't really probably may not even have a non-compete. Is there a particular industry that's known for their non-competes?
There are. The healthcare industry is one, and that's an industry where employers have pushed back and, in fact, issued most of the comments received on the federal level to the proposed federal rule on non-competes. So the healthcare industry has been a big one. Sales industry organizations, financial services, But it's an interesting issue because unlike so many other employment law issues, this is not so much an employer versus an employee issue. On its face, it is because it's the
Yeah, it sounds
employees.
like it. It sounds like it is.
It sounds like it is, and you would think it is because employees are the ones who are subject to these non-compete agreements. But with the little wrinkle that gets added here is you have companies who may want to use non-compete agreements to protect their own interests and avoid their employees going out to a competitor. On the same side, those same companies are hiring and recruiting employees, and they may not have an interest in worrying about the non-competes that their new hires may have with another employer. So in some respects, it's an employer-employee issue. On the other hand, in many industries, there are companies who I suspect do not necessarily like the idea of broad non-compete agreements restricting who they can recruit to their companies.
Let's talk nationally. We have a big election coming up with Donald Trump and Kamala Harris. What are their thoughts, and have they made their positions known on non-competes?
That has not been one of the bigger issues. They've been fighting over a lot of other issues, some of which impact labor and employment law, whether it's immigration policy and wages and minimum wages and union-related issues. They haven't really been too outspoken on the non-compete front. I think part of that is because up until this past year, where we have talked a lot about this federal rule that in fact just got struck down in Texas, this has been a state issue. Historically, whether non-compete agreements are going to be enforced has been determined by a particular state. California, Illinois, Massachusetts, Washington, D.C. are among the states where they have created their own laws, either outright banning non-competes or significantly restricting the ability to use non-competes, whereas other states like New York, Florida, Texas have been a little bit more liberal in their use of non-competes or the ability to use non-competes. But it has been very much a state issue.
So we really don't have too much time, but and I know you're a lot of times wearing the corporation hat, should I say, or the employer hat. How do you break the news to the group that, you know, things aren't looking so good for you here, and things are going to start to change? Or what do you say? Like, where do you get the pushback from them?
Well, I think the big thing that's important to talk about with companies is to really take stock of what the business interests are that you're trying to protect. And are there more narrowly tailored ways that you can protect those interests? You may have interests in protecting your legitimate trade secrets. You may have interests worth protecting relationships with your customers, relationship with your employees. Can you come up with some other vehicle, some other type of agreement that protects those interests without subjecting employees, let alone your entire workforce, to overbroad non-compete provisions that are going to prevent them from earning a living, prevent them from working, while really not accomplishing too much from a business interest standpoint.
And that's where you come in. Listen, Michael, I want to thank you very much. It's been a pleasure. Hopefully you can come back in the next couple of months, give us an update, and tell us how your podcast is doing.
Would love to be back. I appreciate the talk. Thank you.
All right, no problem. All right, stay with us. Today's Verdict has so much more coming up right after this. Okay, welcome back to Today's Verdict. I'm your host and trial attorney, David Lesh. We have joining us today Adam Scott Wandt. He is an associate professor of public policy with John Jay College of Criminal Justice. Professor, thanks for being here today.
Thank you for inviting me to your show.
It's my pleasure. All right, so it's interesting topic, police radios and encryption. Let's just, for the lay people who don't know what encryption is, what are we talking about here?
Encryption of radios is a way of securing the communications so that third parties who are listening into the communications cannot hear what is going on law enforcement channels.
Now, presently, what is the state of our police radios in, let's say, New York City? Can anybody listen in?
You know, New York City is kind of mixed at this point. Over the past few years, the NYPD has been replacing their equipment. As they're replacing their equipment, as they're doing technological upgrades, they've been encrypting more and more of their police radio frequencies. Right now, if you look borough by borough, you'll see that some boroughs are encrypted, others are not. And we see that as a trend all over the country. As police departments across the country have been replacing their equipment with newer technologies, those newer technologies very often offer encryption to law enforcement. And we've been seeing law enforcement all over the country slowly but surely switching over to encrypted systems so that the public cannot easily listen in on police radio communications.
You know, I do personal injury here. I could just see the tow truck drivers, you know, listening in to the radios and finding out where the next wreck is and where the accident is and getting there before the tow truck driver from across the street gets there. But it's more than just tow truck drivers who are listening in. Am I correct?
It is, and that's the concern to law enforcement. There is a history in the United States of the public listening to police radio frequencies. When police first started to use radios, encryption was not possible. And as more and more police departments started using two-way radios, certain companies like Radio Shack in the 1980s started selling radio frequency scanners that anyone could go to a Radio Shack, pick up a radio frequency scanner, and then listen to live police communications. As technology advanced in the United States and around the world, eventually members of the public started taking those radio frequency scanners, plugging them into internet protocol or IP-based systems. And now you could download apps off the App Store on iOS or Android, or even use your web browser and listen to live police communications. No more advanced technology is needed than that. And the problem with that is, one, criminals are starting to use these technologies. Criminals, and it's not a new trend, criminals.
Well, give me an example how your garden variety neighborhood criminal would be listening in. What are they getting from?
Yeah. So one of the more famous cases is a bank robbery in California where the bank robbers, had heavy armor and assault weapons and police radio frequencies. They went into the bank to rob the bank. And when 911 was called, they were able to hear what was going on, understand that police were responding, understand where they were setting up, and act accordingly. But we don't just see it with bank robbers in California. There are dozens of incidents in New York where people who are burglarizing houses, or even as simple as trying to avoid a drinking and driving checkpoint, are using technologies to listen to where the police are, what they're doing, and when they're responding in order to change their behavior and potentially leave the scene of a crime or evade police that are trying to catch them after the crime is over.
It's a cat and mouse. I mean, the checkpoint for the drinking or for just a license check is a great example. You really know when it's coming up. And we have to say, oh, hopefully it's not my car that they picked to pull over. Well, if it is, but if it's not, it's not. But I guess if you hear that on the radio where they are, where they're not going to be, you could plan accordingly.
Absolutely.
Where do you stand on this?
My point of view is a bit straightforward. I'll be honest, I used to listen to police radio frequency scanners when I was young. When I was in my 20s, I had a police scanner. I was also a volunteer EMT, and I would very regularly listen to police radio transmissions. And because of that, I got a really good idea of what goes over those frequencies. Today, as a professor who studies this, I have significant concerns with the public monitoring police radio frequencies. And those concerns kind of go into two different categories. The first category is what we call police operational security. It's keeping our police safe from criminals, helping make sure that they could apprehend criminals, and making sure that the police don't fall into ambushes. So my first concern is of the police and making sure that they could do their job safely, catch the criminals, and get home to their family once their tour is over. But then the second category is equally, if not more, as important, and that's to protect members of the public. Every police department handles communications a bit differently, but one thing is for sure. If somebody picks up the phone and calls 911, let's say they're a victim of a sexual assault and they call 911, What I don't want happening is the name of the victim or the address of the victim, or maybe the name of it or address of witnesses of the crime be broadcast over the radio for the public or potential criminals to hear. That could be a very serious thing. If I had a daughter and she was a victim of a crime, I certainly wouldn't want her name and address being broadcasted over for the public to hear about and talk about. And then we see applications pop up like the Citizen app, where people discuss crimes in progress and crimes that are going on. And I think victims and witnesses of crime should have significant privacy and not be, held out for public scrutiny.
So where's the compromise? Is there one that's possible?
There's definitely a compromise, and I think the compromise is needed, and it lies in the function of the First Amendment, the freedom of the press and the media. There is absolutely accountability and transparency that is provided by members of the press, photojournalists who need to be on the scene when it's actually happening, reporters that want to look into police corruption. There's nothing more important in our democratic society than freedom of the press. Very few things are more important than that. And there is a way that the NYPD or any law enforcement agency could put their police communications live online, where only members of the press with official credentials could log into that website to hear live law enforcement traffic and be able to do their jobs in protecting our democracy.
So where are we heading? What are your thoughts here? It looks like there's more encrypting going on than before, precinct after precinct. Is that follow the leader? Is that what's happening here?
That's definitely what's happening. Here's where we're heading. We're heading into an interesting area. First off, where we're heading is police departments across the country, without a doubt, encrypting their communications. I would expect maybe fire departments following thereof as the technology becomes more and more available. But more importantly than that, where we should be heading is that the decision whether or not to encrypt, the decision of how to release the information, should not be left to the law enforcement agency itself. State and local legislatures should get involved. They should have hearings. They should come up with legislation that mandates or dictates when encryption could be used, when the press could have access, how they could file for access or freedom of information requests. And while I definitely see a trend of more encryption happening, I hope to see a trend of the legislature in different localities coming up with actual rules that police departments have to follow.
Well, we're going to leave it there, and I think that's well said. Maybe, Professor, you can come back in the next couple of months and let us know where we stand with respect to the radio encryption.
Of course, I would always be happy to join you again.
Wonderful. All right, stay with us. Today's Verdict has so much more coming up right after this. Well, that's all we have for today. I want to thank our three guests for joining us, and of course, you, the viewers, for watching. If you have a topic that you'd like to see on a future edition of Today's Verdict, feel free to email me at davidlesh@bronxnet.org. Until the next time, know your issues, reach a verdict. I'll see you in 2 weeks.